Alex here with a high conflict child custody video on parenting coordinators. This is something that I have talked about a lot in the past, but I usually just glaze over it and I've never done a video on it. One of the reasons I never did a video on it was because I never used a parenting coordinator in my case, so I didn't feel like I had enough experience to really talk about it. The only reason I'm talking about it now is because a case published in Nevada up as to how far you can go with parenting coordinators, and it was really astonishing. I thought it was super interesting, so I decided, based on this case, I'm going to go ahead and do a video on it now, and I can explain it a lot better too now that I know what their limitations are, because before it just seemed like one of those things that the judges could order if they wanted to, if they felt like it, and there was nothing you could do about it, which is not true from what I read, and I really like this. So I will just go ahead and go into it. A parenting coordinator is basically a mini judge. It's a judge before your judge. It's a person that you can bring your disputes to that will render decisions just like a judge would, that you and your ex would have to abide by. And if you don't like the decision, you can challenge it. You can go to the district court and challenge that decision. And my understanding is that the judge will have the final call. It's not so simple though. One of the things that I've seen that really disappoints me is that custody evaluators have you sign a contract. I didn't know this. So the judge will order it, which makes sense, but that's not actually the end of the process. When you actually get your custody evaluator, they have you sign a contract. There is, as far as I know, you have to pay for the custody evaluator. I've never heard of it being free. And the contract covers paying the not the evaluator, sorry, the parenting coordinator. Custody evaluators are a completely different thing, and I'll talk about them later. The parenting coordinator has to be paid, and the contract will cover how much their fees are going to be, how much of a retainer you have to put on there, how you're going to divide the fees with your ex, stuff like that. What I was going to go into was that the contracts that I've seen require you to agree that if you go over the custody evaluator's head and take it to the district court and you are wrong or you lose, in other words, the judge sides with the evaluator, you have to pay attorney fees. This is something that I strongly dislike. Existing law, at least in Nevada, and as far as I know, this applies to all 50 states, it's not enough to just win in a child custody case or a divorce case to get attorney fee awards. You have to both win and show that your ex brought it, whatever issue it was, to court without any reasonable basis. And I strongly believe this is what the legislature has set forth in the laws. I strongly agree with them because I believe that the imposition of attorney fee sanctions anytime somebody loses in a custody case when a child's best interests are at stake has a chilling effect. Actually, I think it just terrifies the parent. The losing parent becomes basically scared to ever come back to court. And it actually could do a lot more to make child abuse and neglect worse than actually make it better. I think that these provisions in these contracts by these parenting coordinators, and I think a lot of the judges and lawyers that happen to agree with the other side, which is that you should have to pay fees anytime you lose, which is I agree with in other types of cases, money lawsuits, small claims. I agree. Well, actually, there's no fees in small claims. There's cost awards. But anyway, when it comes down to money lawsuits, I agree that the loser should pay. And I know it's a little bit more complicated that, but it is much easier to get your fees. When it comes to child custody and divorce cases, I disagree. And I don't think the loser should just pay just because they lost. I think you should have to go above and beyond and show that they're harassing you and that they're bringing things to court that have no basis at all in reality. That I can get behind. But there's a lot of these cases where people are trying to protect their kids, whether or not they have an attorney, and they bring an issue that is reasonable and it does matter and they lose, and I don't think they should be punished for that. I really don't. In my case, I went through 8 years of child custody litigation, and I probably wouldn't have gotten as far as I did if I had to pay my ex's attorney fees every time I lost. And from what people have seen, hopefully people know a little bit about my situation, there were issues that I brought to the court's attention that I shouldn't have lost on, like when I wanted to get rid of the midnight exchanges. Why should I have to pay attorney's fees for trying to get the court to change the midnight exchange of our infant child, of our 2-year-old, 3-year-old, 4-year-old, 5-year-old child? You know, fine, if I'm going to lose and I don't appeal it because I don't have money or I don't understand the process, fine, but that's not me bringing an issue to court without reasonable basis. I cared about him having to be woke up at midnight. So to just add in there a $2,000 or $3,000 fine every time I lost, what it's going to do is make me stop coming back to court. And I had other issues later on where I needed to go back to court when it came to his education, when it came to his dental neglect, when it came to physical abuse. And if I had remembered in the back of my mind those last few times I came back, I had to pay $2,000 every time I lost, I may have not gone back to court. So I think that's why the legislature did not put it into the statutes that a losing party in a child custody case or a divorce case has to pay attorney's fees. That it's not enough that they lose. You need to show that they're just trying to harass and annoy the other person. I strongly agree with that. And going back to what I was, first going into here is that the child custody, the parenting coordinators, that stipulation in their contracts where if you go over their head, you have to pay attorney's fees. I strongly disagree with that, and that's one of the big reasons why I do not approve of them. If they remove that from their contracts, or if they at least get the court's permission to put that in there, which I don't think the court should do, but that's a whole separate argument, then I might be able to get more behind the concept of a parenting coordinator. But right now, as it stands, that one provision alone that they make you agree to, that they coerce you into agreeing into, is enough for me to be against parenting coordinators in high conflict custody cases. That aside, I did want to talk about what coordinators are supposed to do. As I mentioned, they're a mini judge. They're a judge before you're a judge. They're supposed to save money and they're supposed to be quick. I don't know if this is actually true. In fact, if anyone has had a parenting coordinator, please post in the comments below whether or not they were a benefit to your case. Did they make it cheaper? Did they resolve issues quicker? Do you feel that they actually made the situation better, or did they make it worse? As I mentioned, my personal opinion is another point of contact is another attack surface for a high conflict child custody X to abuse. In my opinion, in a high conflict child custody case, they don't work. And in their defense, as I mentioned, now that I recall watching those parenting coordinators and videos, I do recall them testifying in the capacity of a custody evaluator, which is different. I imagine maybe they don't get involved in high conflict child custody cases. Maybe they just get involved in cases where there's some conflict, but there's some ability for them to resolve that conflict. It's not something where they're dealing with a personality disordered person or a high conflict person. But anyway, that's what they do. That's what they're meant. That's their purpose. I imagine that they probably are quicker if they actually do resolve the issues and it doesn't end up going to court every single time. I don't know if they're cheaper. They defend themselves by saying that you pay their fees, which are less than the fees of an attorney. But who knows? If you end up going back to court on every single issue or most of the issues, you're just going to end up paying for an attorney and the custody evaluator. The other concern that I have is maybe judges just don't even look into the issues. Maybe this is something that I'd like to get some feedback on too. If people here do have experience challenging a custody or a parenting coordinator's decision, did the judge just side with him and not even really look at the details? That's one of the concerns I would have, is that the judge will just check out. They'll just read the decision and just approve it every time, just rubber stamp it. If the judge checks out and doesn't look into the logic and the basis behind the parenting coordinator's decision, then it's almost as if the parenting coordinator becomes the judge, which may not be a great thing because they're not elected and they're not trained. I know some of them will claim they have training as far as dealing with high conflict cases and mediation, but they're not trained in the law. So they may feel something makes sense morally and ethically that is very counterintuitive, that the legislature has done research on and passed a statute on. They might not understand that. And it can get really hairy if they're dealing with thorny issues such as relocation. See, that this is something I'm curious about, is how much authority do they really have? So having said that, I'll go ahead and go into that case, that case that came out in Nevada. Unlike my last video, which is an unpublished decision on mandatory mediation orders, this is a published decision on parenting coordinators. It's Bautista versus Picone, I don't know how to say that last name. I'll go ahead and post a link to it in the description below. It's a Nevada Advanced Opinion, number 44, came out this year. I'll go ahead and post a link so you guys can find it. But what happened here was the family judge appointed a parenting coordinator, and the Supreme Court didn't like it. They reversed his decision and sent it right back to him. And they basically set some criteria forth for when a parenting coordinator can be appointed. And I guess this was addressed previously in another case called Harrison v. Harrison. I'm not going to post a link to this one. You can read about their reference to Harrison in the case that I'm talking about, the Bautista case, if you really feel like it. But the Supreme Court apparently, and this is what I was waiting on because I really didn't want to talk about it until I knew for sure, There's 4 criteria that the judge has to consider before they appoint a parenting coordinator. The first one is that the custody dispute is highly contentious and multiple custody pleadings have been filed. So my understanding is that these several factors have to all be considered. I'm not sure if they all 4 have to be satisfied, but I imagine that they do. With that, I'll go into the other 3. The second one is that the parents consent to the appointment of a coordinator. I really like this. This implies to me, now again, I haven't read this very carefully, but it implies to me that if one of the parents doesn't want a custody evaluator or a parenting coordinator, the court just can't appoint one. And I really appreciate that because, as I mentioned, the coordinators have you sign a contract that says that you have to pay attorney's fees if you lose. If you take the issue to the court and the court doesn't override the coordinator, you have to pay fees. And I disagree with that. That alone would be enough for me to just say, no way, Jose, I do not want a parenting coordinator in my case. So I'm really happy that they made that one of the factors in Nevada. If anyone here has a parenting coordinators has gone through a parenting coordinator in a different state, let me know if you have similar criteria. Like, I don't know, maybe other states allow the judge to appoint a coordinator over your objection, basically. Just say, it's nice that you don't want one, too bad, so sad. You're going to have a parenting coordinator whether you like it or not. Looks like in Nevada, that is not the case. The third prong is, or the third criteria is that the parenting coordinator's authority is limited to resolving non-substantive issues. That's a big deal to me. I don't know for sure because, again, I'm not going to research this like crazy. My custody case is over and I'm not going to spend time on this. But what I imagine this implies is that the coordinator's authority cannot go into areas such as authorizing relocation to another state, such as modifying custody, modifying physical or legal custody. These are things that I do not think a coordinator should have authority over. Coordinator should be able to talk about changing visitation when somebody changes their job, dealing with an issue as to where you're going to exchange the child. If you're having problems doing it at your house, maybe you should go to a third location like a Wendy's or a Walmart or something. Phone calls, when you should be able to call your child, what times, how often, how frequent, vacation schedules, holiday schedules, stuff like that. That makes sense to me. I can get behind that. But custody, modification of custody, or permission to relocate, those are serious issues that I'm not comfortable with the coordinator having any authority over that. So it's nice to see that is the third criteria. And the fourth criteria, and this is the one, as I mentioned, in the Harrison case, they already talked about this. The fourth criteria, which I'm about to talk about now, this is the one that caused this decision to reverse. And this is the one where this judge overstepped his bounds. The fourth criteria is that the district court maintains the final decision-making authority. Basically, no matter how much authority the parenting coordinator has, the district court has to be where the buck stops. He cannot check out of this process, and this judge appears to have done that in this case. There were certain things the parenting coordinator, it was either that or the third criteria, he allowed the coordinator to make decisions on substantive issues. It was one of the two. Please read it for yourself and determine this for yourself. I'm not going to go into it like super detailed like I would if I was representing myself in my own case. So I'm just here to do videos to get everyone pointed in the right direction. I want to just repeat that right now. So what appears to me is that this judge allowed the parenting coordinator to be the final decision-making authority in certain areas, and by depriving a parent the right to ultimately go over the parenting coordinator's head and go to the district court and get a final answer on a certain issue that they disagreed with the coordinator on, he violated the there's constitutional principles in place here. And I think I'm just going to, in a nutshell, it's that we as citizens of the United States have a right to access to the courts. The courts have a duty to sit and preside over, whatever issues are before them. It's not a choice, it's an obligation, it's a duty. They must do this, and you can't use parenting coordinators to get around this. Even if, apparently, according to this, even if the parties agree, you can't do that. So by delegating his decision-making authority to the parenting coordinator, he violated the fourth criteria, and his decision was reversed, sent right back to him, and he had to basically fix that. I'm not sure how this case ended up being resolved in the lower court. I'm not doing a video on that. I just wanted to talk about this published opinion. Hopefully other people will give me some feedback in the comments below, because I'm really curious. Me having no experience having dealt with a parenting coordinator,